Some bilateral treaties have a time limitation. They provide a time limit within which an investor has to lodge a request for arbitration. This is the case with the bilateral investment treaty between Colombia and Chile. According to this particular bilateral investment treaty, the time limit is 39 months from the breach. Now the question is, what should be an approach of an arbitral tribunal to the cases of a continuous breach? The principle of a continuous breach says that, there is no precise time limit. There is a beginning date, and then that date, extends. The breach is continuous, and as long as it continues, the investor has the right to lodge a request for arbitration. However, the arbitral tribunal decides to limit this principle, the application of this principle, and they do it in two steps. The first step is that they say that the investor should not wait until the moment when he would be able to calculate all the damages. In other words, they say that the request for arbitration should be lodged even in the impossibility to calculate all the damages, to assess all the damages that the government will cause to the investor. And then the second step is that they refuse to apply the case law of the European Court of Human Rights. Obviously, this case law is not that binding, let's say, but it is a good practice in international investment arbitration to apply the wisdom of the European Court of Human Rights. In this case, in Rios versus Chile, the arbitral tribunal says that there is no clear case law of the European Court of Human Rights on this issue, and this is not true. This is not true. Let's take the case of the impeached president of Lithuania, Paksas versus Lithuania, where I was the counsel of the impeached president. We have lodged the application with the European Court of Human Rights, in fact, 18 months after the end of the impeachment, while the time limit was 6 months. Nevertheless, the European Court of Human Rights accepted the case, declared it admissible because the breach was of a continuous nature. So the nature of the breach was that the president of Lithuania was impeached, and then he was prohibited until the end of his life to run for elections, to run for new elections. So this was a lifelong disqualification for participation in presidential elections. And this was a continuous measure. The same was the argument in the case Rios. However, it was dismissed because there is no clear case law of the European Court of Human Rights. This is not true, this is a mistake, but this is what happens quite often with this, yes, it is a general philosophical problem of our human adjudication. However, Rios and Rios, there are two individuals, they still have the right to continue their litigation against Chile at the level of the United Nations Human Rights Committee. Subscribe to my channel.